Imagine a justice system built on rigorous evidence, not gut instincts or educated guesses about what works and what doesn't. More people could access the civil justice they deserve. The criminal justice system could be smaller, more effective, and more humane. The Access to Justice Lab here at Harvard Law School is producing that needed evidence, and this podcast is about the challenge of transforming law into an evidence-based field. I'm your host, Jim Greiner, and this is Proof Over Precedent. So welcome to a new edition of Proof Over Precedent. I'm Jim Greiner, your host, and with me once again is the incomparably wonderful Shannon Sewards, who is at, and Shannon, why don't we get you again to remind us who you are and where you are right now?
Yes, I'm the director of the Human Research Protection Program, administrative director of the Institutional Review Board, IRB, at a large academic medical center in northern New England.
Terrific. And formerly the head of the IRB at Harvard.
Yep.
And that's how we met, as people who have listened to previous Proof Over Precedent podcasts would know. And I continue to be in mourning, wearing black veils every day because of your departure, Shannon. So I just wanted to mention
You're
that.
very kind. You're very kind.
And tell us a fun fact about yourself.
So, fun fact, I have a new addition to my office. It is a taxidermy deer head that randomly I purchased in Salem, Massachusetts about 10 years ago. I just came across it. It is a female deer head, which I think for hunters is probably not the prize. So that's a little bit of a challenge. So when we moved here from Massachusetts, we had said deer head. And my husband was very concerned about it being in a public space because one, we bought it at a thrift store in Salem, Massachusetts, and two, it is a female deer head, and three, it's not our prize. It was some random hunters in the 70s. So because of that, it is now proudly displayed because I feel I have to respect and honor it in some way as the backdrop of my meetings. It's in my background for whenever I join a meeting. I do get very odd looks. It's a conversation starter, and people think I'm some sort of, outdoors hunter type person, of which I am not. So it's fun fact.
Well, you do enjoy the outdoors more
I
than, for
do.
example, I do.
Correct.
But you're saying you're not a regular hunter.
At all.
Got it.
At all.
Terrific. All right.
At all. If I think about our property as a safe space for the wild creatures in the area.
Terrific.
Yes.
Terrific. Well, super luckily, a Proof Over Precedence podcast, so it won't be too distracting to our listeners. And even though you and I are on video currently, I will endeavor not to let it interrupt my conversation with you too much. Super. So, with your grace, I thought we might talk today about the waivers of informed consent set of regulations in the Common Rule, and also, if we have time at the very end, whether we could compare those to the exceptions to informed consent
Hmm.
regulations that are in a different regulatory regime. And we'll talk about how it could be that there could be two sets of regulations that would govern or that would speak to such similar issues.
Hmm.
And we'll talk about that in just a moment. Something we've hinted to or alluded to previously, that the regulations, for whatever reason, the federal government's regulations generally have one set of rules that apply to approvals of studies of drugs and medical devices involving
Hmm.
human participants, and then another set of rules that applies to almost everything else involving
Hmm.
human participants. And so we're going to begin and spend most of our time, if it's all right, on the set of rules that apply to almost everything else, because that is, in fact, what um, would govern legal RCTs and govern social science RCTs. And so does that sound okay?
That sounds great.
Okay, super. So we're going to start out for folks who like to look at the regulations themselves, and of course these are available online, at 45 CFR 46.116, so 46 section 116.
Mm-hmm.
And and this is the waiver of informed consent regulations. And most of the operative language is, alas, in subsections E and F of those regulations, if I have that
Yeah,
correct, if I have that right.
you're
For
correct.
most people, they don't even encounter E and subsection E, but we're going to talk about it in just a second, why it might be tempting to think that that could solve potentially a lot of the problems that arise with regulations, the applications of these regulations to legal RCTs and to some social science RCTs. In fact, subsection E is pretty narrow, and so we'll talk about that. And then we'll talk about subsection F. But to set the stage, basically what we have concluded, if we're at this stage, is that we have human subjects research, which means that we have participants, human participants,
Mm-hmm.
and that we the default situation in that setting when we have those two conclusions is that we will elicit informed consent from them and begin by default typically with some sort of signed writing.
Mm-hmm.
That's the sort of general, go-to way that IRBs and researchers handle, documentation of consent is with a signed
Mm-hmm.
writing. Nowadays it isn't always wet signatures. Sometimes it's an electronic signature, or like clicking on a survey button or something like that. But there's some sort of signed writing
Mm-hmm.
that is then recorded. But in certain situations, it is permissible for a researcher to ask and an IRB to grant a waiver of informed consent. And so that is a place where, in my view at least, there is a particularly poor fit between the regulations themselves and the legal setting. And
Okay.
so it causes a great deal of consternation among researchers and then difficulties with difficult decisions for IRBs. So let's just get through the basics here. First of all, there are two subsections, E and F, and E allows an IRB to waive informed consent with respect to certain types of investigations of research into state or local benefits programs or service programs. Is that correct?
That is correct.
Yeah.
And E is actually quite rare
Right.
to come across.
Right. It is something that I think legal researchers would have an interest in because, for example, we at the Access to Justice Lab have several, or have had in the past, several studies that have investigated providing legal assistance in the context of people applying for government benefits or public service programs. And some of those have involved situations that might meet the terms of subsection E's waiver requirement, or I should say pathway, waiver of informed consent pathway. But walk me through generally, we don't want to read the entire set of regulations. Walk me through generally, what does the research have to involve in order for it to fit within this exception involving public benefit or service programs?
Well, first it has to be conducted by or subject to approval from state or local officials. And so that is why it's a very rare waiver to come across, is that most academic IRBs are not in the situation of seeing research that is conducted by or approved by state or local officials. Most likely it's your local investigator that's initiating the research.
Now, pause 1 second there, because this actually has come up for a previous study that you and I may have worked on together. I forget. Um, uh, if the investigation is initiated by a local researcher, in other words, it's a researcher saying, "I've got this idea, I want to investigate," but in order for the investigation to go forward, it requires approval of the state entity or the local entity, for example, because you need their approval and their cooperation to obtain data, would that be sufficient?
Um, well, that's one step. That's the first step.
Right, but sorry, that meets that part, right? Is that correct? That meets that part. And then there's needs to be other things that happen we're about to go over. But is that right?
Correct.
Yeah.
Yes.
Okay.
Yes, yes.
All right, super. So then go on.
So, I mean, it's specifically stated within the requirements of what that waiver or alteration would include. So it's conducted by or subject to the approval of the state or local government, and it's designed to study, evaluate, or examine, is what the research, regulations state, that it's a public benefit or service program, that it's looking at procedures for obtaining benefits or services under those programs. It might lead to changes to those programs or procedures, or changes in methods or levels of payment of benefits for those programs. So it's very specific to looking at and examining a public benefit program or service. And as such, is why it's so rare to actually see a waiver come in under this regulatory citation.
And just to make sure that was an or of all those things you listed. You don't have to meet all of those, as any one of those would be enough. Is that right?
Well, it does have an and.
And at the end, because then we have to have that last thing, which is what? The first things you mentioned so far are all or. So if you're on any one of those, plus you need the last thing, which is the last thing is
The research could not practicably, one of my favorite words actually, be carried out without the waiver or alteration. And the thing to note is the research itself could not be conducted without this
right,
waiver.
right,
And that statement is carries over to the other rationale for a waiver, which is more common.
right, which is where we're headed next. So
Yes.
why is it that, do you happen to know, well, actually, let me just go say this first. Would you consider, say, the criminal justice system, where people get prosecuted and if convicted get put in jail? Would you consider that a public benefit or service program?
I'm not certain. I would have to do some research on that.
I would not. I mean, it would be somewhat surprising to me if that were considered a public benefit or service program. And the reason, of course, that I mentioned this, nor would I consider the civil justice system in court a public benefit or service program, because I think when people think public benefits, they think things like Social Security for the federal government, or unemployment benefits, which are federally funded but state administered, or in various ways, joint federal state funding, et cetera. I think that's what people typically think of when they think of benefits or service programs, right? If you're going to offer services of some kind, it's maybe taking care of someone when they're sick or you're disabled or something like that. Is
Exactly. Well, would, and just
Yeah,
asking, would a like a legal aid program?
right. That might do it. Although legal aid is typically not state or local government funded or overseen. Excuse me, it can be local government funded, but the idea is that in order to prevent the state from interfering with what legal aid does, it gives the money to an organization and then
Uh,
tries to stay away from it. Um, and so I'm not even sure that even an organization that receives federal funding from the Legal Services Corporation. Of course, that would be federal, which is not
mhm,
covered by this exception anyway, because that's state. But
mhm.
say a state equivalent, I'm not even sure you would consider that a state service program, because the lawyers, put it this way, who would participate in that would be appalled by that characterization, because that would suggest that they are too beholden to state masters, which and in many instances what they want to do is sue those state masters, right? Litigate against them. Right. For example, so this provision, put it this way, has typically not at least occurred to me, and I'm wondering again of your reaction, as a way to try to suggest that an exception is appropriate in a criminal justice setting. Um,
Most likely not.
Most likely not, because again, I think it would be a bit of a stretch to characterize that as a public benefit or a civil or service program, or even a civil justice setting. In a piece of divorce litigation. I think many people, at least I would find it surprising to have that characterized as occurring within a service program, a public service program.
I agree.
Okay, so this for those of us, including me, that in some cases find ourselves asking for waivers of informed consent to conduct research. Um, this is probably not going to be helpful very often, exactly as you said, as you suggested, Shannon. And then, of course, we have the practicability standard, which actually, in some senses, we're going to talk about that again. In some senses, we can meet. But again, this isn't going to help us very much. So then we go on to the workhorse provision, which is subsection F.
Mm-hmm.
And that's, again, fairly long, right? I'm sitting here scrolling down, and that can't fit in even on all fit in one computer screen. So but the real workhorse is subsection F3. So again, for those of us who want to, again, we'll put these links on the Access to Justice Lab's website. But again, we're in Title 48 of the CFR. So 45
Mm-hmm.
CFR Part 46.116 F3 is the real workhorse here. And so
Mm-hmm.
walk us through generally what that requires for a waiver of informed consent.
So there's two pieces to it. So one is the waiver or an alteration.
Mm-hmm.
Okay, so a waiver would be a complete waiver.
Mm-hmm.
There's no consent process whatsoever, and the alteration is that you're removing some elements of consent, of what is required, and that's in the previous sections of 116 that list the elements of consent.
Yep.
The interesting thing about this is that this was revised when the 2018 requirements came out. So the reason for that is they added a new section in the informed consent called key information.
Mm-hmm.
And if you look at the specific provision, which is the F portion, it says that you can only waive sections B or C. And key information is in section A.
Oh, Lord.
So this is, I
Okay.
know this has been, I don't want to deviate too much, but this
Right.
has been a real challenge for the social behavioral research community,
Mm-hmm.
because what it does is it unnecessarily lengthens the actual informed consent form. And given that most social behavioral research has shorter informed consent forms already, it's just a real duplication of information. So I just wanted to point that out, that if you hear back from your IRB saying, nope, you got to keep a key information section, but we can waive the purpose of an element. That's why, is that
Right.
this is a new provision for that, which is a little bit challenging for researchers and the IRB
It
together.
does seem like perhaps a drafting error almost, if of whoever,
Well,
but who knows? Or maybe it
it's
was on purpose, but
there was a lot of chatter about this, and the then director of OHRP was very headstrong about the inclusion of key information. And I mean, from a biomedical perspective, if you're doing a biomedical research study where you have a 40-page consent form, yeah, having that elevator pitch up front makes a lot of sense,
mhm,
but not when you're dealing with a 3-page consent form.
right. And remind me again for our listeners, what is OHRP?
Office for Human Research Protections.
Which is
That is under Health and Human Services, and
mhm,
they are, and the office still exists in name. I don't know how
mhm,
many people are there.
right, because of
Um,
the Doge efforts, but go on.
correct, correct.
Mhm,
And their mission is the protection of human subjects that take part in research,
mhm.
and they are the owners per se, 45 CFR 46 in the subparts.
Right. So we've talked about them before in previous podcasts. Just wanted to remind listeners that this is who they are, that this is who OHRP are. Okay, so right. So now let's get into then under what circumstances, and these are and this list that we're about to go through.
Yes,
This is a great big and. So all of these things have to be true. So let's walk through then and try to keep it as in as much normal English as we can, which will not be
great.
easy, but we're going to give it our best shot. So walk us through it.
Great. So the first step, and this is the most important one, is that the overall research study cannot be greater than minimal risk.
Right.
So it has to be a minimal risk study. And the way that OHRP defines that is minimal risk are events and procedures that you would occur in normal everyday life from a normal person's perspective. Yes, is there subjectivity involved in that? Of course. But there are some you know, good examples of what would be considered no more than minimal risk.
And this is where we're going to run into a huge amount of trouble. So let's get through everything, and then we're going to come back to this. And
Got a
because
feeling.
because this is going to be the thing where the rubber's going to hit the road, where expletive deleted hits the fan, whatever your favorite analogy is. So
Exactly,
let's
exactly.
because it's going to turn out, I think, that, and this is, by the way, where we're in real trouble in terms of the regulations applying to the legal system. There actually are a few situations in which the legal system interacts with human beings in a way that we need research that
Hmm.
involve only minimal risks.
Hmm.
Unless we are to interpret that term, that phrase, minimal risk, creatively, which in my view has its own dangers. Interpreting something like that as creatively as, in fact, IRBs have interpreted it before. I'll just say,
Correct.
yes,
Exactly.
right.
Exactly. And
It's
there's
happened.
also some sort of tools and things that IRBs look at to provide some credibility for the justification of whether something's minimal risk or not,
Right.
which we can get into.
Okay, super. So
Um,
we need minimal. The research involves no more than minimal risk to the subjects. Go on.
exactly.
Hmm.
The second one is our carryover from the previous
Got it.
waiver.
Hmm.
Okay. So the research could not be practicably
Practicably.
blah, carried out without that waiver or alteration.
Hmm.
Basically, you couldn't do that research if you didn't have that waiver or
Yep.
alteration.
Hmm. Go on.
The third is a new one. That's if you're using identifiable private information or identifiable biospecimens.
Which we don't
Again,
do with much in law, but it's just yet
right?
another
But
indication
it's
that all research is medical in terms of the folks who drafted these regulations. But anyway,
it's
go on.
there.
Yep. Yep.
Again, it could not be practicably carried out without using it in identifiable format. And if it doesn't apply to the research, then you could check a big NA on that
Hmm.
one. So that's a
Hmm.
possibility.
Hmm.
I think the fourth one is, from my perspective, the most important,
Hmm.
right? Is that if that waiver alteration is in place, it's not going to adversely affect the rights and welfare of the individuals that take part in the research. Okay, because
So
that's the IRB's jam,
So,
right?
right, absolutely. Although, at least I might question, how is that not duplicative of the minimal risk, which was where we began. And so, but well, let's go on. Let's get everything out on the table before we start to ask questions
And
about it.
that's actually a very good point.
Yeah,
I will
go
agree.
on.
And then the fifth one is sort of, an interesting one that's in there is that whenever appropriate, okay, so whenever appropriate,
Hmm.
that those individuals will be provided with information after participation. So I believe this speaks to those studies that either have incomplete disclosure or deception that are involved, which would in and of itself more than likely meet all of these criteria.
Yep. Right, and it's actually the phrase here, the regulatory phrase. It says, where appropriate, you're going to give additional pertinent information after participation to the subjects or legally authorized representatives, which are frequently present or in legal settings, or maybe should be frequently present in legal settings in the form of counsel, in the form of a lawyer, for the individual. So
Yeah,
this is
I think
also important.
in this regard, they mean it in the true sense is that it's a proxy for the individual insofar as
Exactly.
consent.
That's what
They're
they
like
think. I think when they're writing this, they're thinking about
correct,
a medical decision-making proxy for an
correct,
incapacitated patient. On the other hand, you write
exactly.
that phrase, legally authorized representatives, and I think again, anyone in the legal system would say, oh, well, I know what that is. That's the individual's lawyer.
Yeah. Again, pointing back to, these are very much biomedical regulations.
Regulations.
Yeah.
Okay. So this is what we need, all of those things again, it to be present before an IRB can either grant a waiver or an alteration of an otherwise applicable consent process.
Hmm.
Okay. All right. And now let's go back and talk about some of them, if that's all right. So, and
Yep.
again, you can tell me whether you think the following set of questions that I'm going to ask you. I'm going to give you some research that the Access to Justice Lab has pursued or is pursuing,
Hmm.
and some of that and some of those we have requested, or that other researchers have pursued or are pursuing, and ask you whether they are appropriate. Usually, the problem is no more than minimal risk, or in the alternative, adverse effect on the rights and welfare of subjects. Again, you tell me which one you think is the better regulatory section to analyze this under, or both,
Sounds
right?
like a pop quiz to me.
Exactly. Well, I'm just actually, there's no, as far as I know, there isn't a right answer. Although, of course, I hope that in many situations, the answer is that the research can go forward, because in many situations, I think is necessary, right? We really badly need the research. But one that was caused a lot of sticking points is one that came up in a previous conversation you and I had, identifying who the participants are. We've talked
Mhm.
about that previously. So let me get this study, but this is a separate question: is if we have participants, can we waive informed consent with respect to them? So the situation here is, again, research we've talked about before in a previous podcast. What we have is folks who are arrested, and they are unable to bail themselves out immediately upon arriving at the jail, which again, a very small fraction of the population is allowed to do after they're fingerprinted and photographed. If they have a sufficiently high credit limit, they can immediately bail themselves out. Most people can't do that. And so they go before a judge or a magistrate or a commissioner, somebody with, hopefully some legal training. And that person decides whether they will be remanded to the jail without the possibility of posting bail to achieve release, whether they will be achieve released without having to post bail. So the former is called remand. The second one is called OR, own recognizance release, or OR release, or whether they will only be allowed to go free if they post a certain amount of money with the court, which they will receive back at the end of a criminal case if they behave well, in the sense of make all their court appearances and avoid rearrest and and comply with other conditions, such as maybe periodically checking in or wearing an ankle bracelet or something like that. Even if they're convicted, they'll get that money back, but they won't get the money back even if they're acquitted, if they do something like miss a court appearance or miss too many court appearances, or they are rearrested or something like that. Then the money will be
Mhm.
forfeited and the state will keep it. So the idea is to have a financial amount of money on the court's bank account, which the court keeps as an incentive for behavior while you're released. Okay. And the research involves figuring out whether providing the judge, the commissioner, the magistrate, we'll say the judge, a risk assessment instrument at the time of that decision, improves outcomes, allows the judge to make better decisions about who is at higher risk and who's at lower risk. Typically, who's at lower risk and who can be safely, or at least as far as we can tell, because this is some involving future prediction, safely released OR. Right. And so the risk assessment instrument is just basically a set of quantitative scores that come from criminal history or demographic information about the defendant or the defendant's housing circumstances or work circumstances or whatever. And it purports to provide the judge a quantitative score of risk, some band or some high risk, low risk, medium risk qualification or something like that. And so the proposal, which is again a study that the lab has pursued and we're going to have feature on Proof Over Precedence, a set of studies, is to randomize whether the judge receives the risk assessment or doesn't receive the risk assessment in this setting when the judge makes these decisions. Most of the time, not always, they are made in sort of 2 to 3 minute hearings where the defendant is either physically present or on a video before the judge. Maybe there's a defense lawyer, maybe there's not. Maybe there's a prosecuting attorney, maybe there's not. And it's a sort of assembly line process where 3 or 4 minutes per defendant at most, and the judge makes a quick call. And so we're going to randomize whether the judge has the risk assessment instrument or doesn't have the risk assessment instrument, and try to follow outcomes to see whether, in the cases in which, or the defendant says to whom the risk assessment instrument is present, end up with better criminal justice outcomes, maybe lower incarceration rates, lower crime rates, lower failures to appear rates, better racial balance, whatever it may be, whatever your outcome variables may be. And so that's our research setting. And so let's walk through here and see whether this might qualify, because the first question we faced, which is what we talked about last time, is whether the arrestees themselves are participants.
Mm-hmm.
And I think you and I at least presumably agreed that or came close to agreeing that probably not under the regulations, but it's not 100% clear, but probably not, because we're not interacting with their environment or manipulating their environment. The judges are participants, but the arrestees only sort of indirectly. However, if you conclude that the arrestees are participants, then by default, you would have to go get consent unless you can qualify for a waiver.
Correct.
And so the question then is, would this qualify for a waiver? So with that in mind, can you walk me through how you might think about applying these regulations to that setting, and what sorts of questions you would want to ask as you go along?
Well, basically, the questions that would be asked of the researcher would roughly follow the criteria for the waiver of, explain how this research involves no more than minimal risk, explain how this is something that one would encounter in everyday life. I think the real key to this one here is, well, why couldn't you get consent from these individuals? What impact would this have on your research to get consent? Would it bias results? Would it introduce some additional factors? Really, what is the rationale for having this waiver? So that would be a key piece that the IRB would want to know, because the researcher would be in a better position to assess that.
Okay, that's excellent. Let's start there. Let's continue that right there. So there's two
Mm-hmm.
things that I said when this came up, and I
Mm-hmm.
would say the research as a researcher. One is that operationally it's impossible to get. Actually, there are three things. One is operationally it's impossible to get informed consent, because operationally the jail and the court don't know who will appear at the hearing, the sort of 2 hour set of assembly where they're going to assembly line people through. They don't know who's going to be there sometimes until a half an hour beforehand. And they're typically trying to get 30 or 40 people through this process in a 90-minute period. And so, and it's a secured, I mean, everybody's in handcuffs, right? So, or frequently they are, right? Maybe not everybody, but frequently there are certainly some people are even more heavily secured, right? They're in leg irons and that sort of thing. And so it would be impractical to have a study officer in the secured area of the jail talking through, with folks, in the amount of time that they have. So that's sort of when again they don't even know, and in some instances until just shortly beforehand, who will appear at this particular, who will go through at this time, right? Who will, and so that's one. Number two, it is against the interests of the participants themselves, if they are participants. And again, I don't think they should be.
Mm-hmm.
It's against the interests of the arrestees to distract them from a highly consequential hearing, in which what they should be doing is thinking about what they're going to say to the judge to get out of jail. And they shouldn't be thinking about anything else. And again, you might say, well, let's get the consent hours beforehand. We don't know who's going to go at a particular hearing or whether they're going to go to the hearing at all. So we can't do it earlier. right? And so the only time you could do it would be when they're about to go in, and that's the last time they want to be thinking about anything else. And then the third issue is, what is at issue if you don't waive the consent? I think ordinarily the idea would be you go back to the default process, whatever there would be without the research. But here that's actually extremely difficult to identify what the process would look like if there were no research, because frequently this research occurs right at the moment when a jurisdiction is thinking of transitioning to a system that doesn't include one of these risk assessments to a system that does. And there's no default, right? There's no situation. So the person refuses, do they get the risk assessment instrument or do they not get the risk assessment instrument? Right. And if they don't have a choice in that, then it's not clear they should have a choice, because all the data we're going to gather on them, say, is publicly available, right? I mean, you can download it from the internet and anyone can log in, right? So it's not like we're following them with surveys or anything like that. And so they wouldn't have a choice in whether the judge had the risk assessment instrument or didn't. In fact, they frequently would never know whether the judge had the risk assessment instrument or didn't. They might not even know that, right? And certainly not something that would be salient to them when they're trying to figure out how to get out. So how does that inform the decisions? The reason why, what I'm particularly wondering about here, none of this speaks to minimal risk, which I think it would be hard to characterize this study as as actually involving minimal risk. And so with all of that in mind, tell me how you would go.
It's a lot to unpack.
Yeah, exactly. Go for it.
So, well, I think, in regard to the minimal risk piece, a lot of IRBs will use, so what we're talking about here are studies that are a certain review level. Okay, so this would be studies that are either at the expedited review level or those that go to the convened IRB, because there's an uncertainty of risk.
Right.
And that's when the full breadth of the regulations apply. There are lower review level exempt research and so forth, and this wouldn't even be a consideration because consent is not a requirement for those type of reviewed studies.
Right.
So at a bare minimum, a lot of IRBs will use the expedited categories as a quasi assessment of whether something actually is considered minimal risk or not. And those are predefined categories that largely speak to the research design. Okay. And in and of themselves, those cannot include greater than minimal risk. So this is, that is used by a lot of IRBs. However, there are a lot of studies that may not fit in expedited category and still be considered no greater than minimal risk. And those actually have to go to a convened IRB for review, but they're not risky per se. It's just how the regulations work. So depending on the IRB you're interacting with, they may be utilizing the expedited categories as their threshold for what's considered minimal risk or not. But I would say, is this something that one would encounter? Is this just a standard thing? Are you introducing more risk? And the thing that speaks to this as well in regard to whether something is practicable or not, and whether that looking at any of these criteria is that, these are like kind of the instructions for the underbelly of the regulations, which is the Belmont report, right? And so consent is one of the, respect for persons, is there an importance in people to know what they're participating in, what are the risks, what are the alternatives, etc. And balanced with that is beneficence, right? What is that risk benefit ratio? Most research that takes place has no benefit to the individual, right? And so we're looking at societal benefits. So with this, it's not really looking at one specific aspect, but looking at the overall research is what would be gained from this research taking place? Is it important or is it even practicable that individuals have a consent process to choose whether or not? Does the overall importance of the research and the benefit society somehow supersede the requirement to have consent. So there's a couple different angles to look at this, and I think looking at it from a more comprehensive perspective is the better way to do so. Of course, that's my personal opinion.
Mm-hmm.
I can't say that a lot of reviewers land in that same place.
And that makes total sense to me. And I think it is at least I'll put it very mildly. One can make a plausible case that this research should be approved, and in fact, it was when you take those broad considerations into account.
Exactly.
But it suggests to me that the regulations as written might be a poor fit for this situation because I think it's very difficult to suggest that an intervention that carries with it the risk of greater incarceration and even worse, greater unnecessary incarceration, which could very well be the outcome of using these risk assessment instruments. We don't
Mhm.
know.
Mhm.
No one hopes for that. In fact, we're
Yeah,
hoping for the opposite. We're hoping that there will be decidedly less incarceration, certainly less unnecessary incarceration, right? But nevertheless, the risk of greater incarceration is there. And I guess my thought is it's difficult to characterize that as minimal.
correct. And then you would also have to look at, what is the basis of this research?
Mm-hmm.
What is your springboard?
Right.
What is the previous work that's been done?
Mm-hmm.
What can you document? Because, that initial approval is a best guess.
Mm-hmm. Mm-hmm.
And you have to see what takes place. Did anything go sideways? Did anything go wrong? Did an event occur, etc., to really see how is this playing out in real life. So that initial assessment may be completely wrong.
Got it.
And so that's, I mean, I think that's the real challenge is
Mm-hmm.
that you really have to look at what is being provided to the IRB in order to assess this, what work has been done previously, what can we, what is the information we're working from
Got
with
it.
that. I think the challenge here, especially if it is and this is most IRBs are set up this way, is that it's an IRB staff member making this decision,
Mm-hmm.
sometimes in isolation,
Mm-hmm.
which isn't necessarily the best scenario
And
to be
sometimes
there.
someone who's not familiar with the legal system, which is an additional problem because that
Exactly.
means the researcher is at an enormous informational advantage vis-a-vis the regulator here, the IRB
Exactly.
staff. Mhm.
Exactly. And I always encourage researchers too, is that so like everyone, the people that are in the IRB office or the IRB members are not perfect,
Mhm.
and they may not have a full grasp
Mhm.
of everything that might be taking place. If, you get a decision that just doesn't seem to align, um, I have always encouraged researchers to speak up
Mhm.
and to ask about, how did you get to this decision? Did you know about this, or that? Because they may not be aware of it. So if that is the case, I've always encouraged researchers, and that there is an appeal process. Most IRBs do have an appeal process. And so I would encourage researchers who may be in this position to actually utilize that.
Mhm. So let's actually go back because I diverted you, which I shouldn't have done. I diverted you away from the practicability concern. If we are going to try to stick to sort of the language of F3 here, how did you find the suggestions that I gave you about why this research could not practicably be carried out without a waiver? Did you find those sort of persuasive, or did you think, oh my goodness, I'm going to have five more questions and here are two of them?
I thought it was justified,
Hmm.
insofar as the challenges and
Hmm.
how actually, and from what I picked up on, it sounds as if you did introduce a consent process, it may actually be a poorer outcome for the individual.
Yep.
And this is, an interesting concept in that a lot of times with especially deception studies or
Hmm.
studies that have incomplete disclosure,
Hmm.
sometimes informing people of how they've been deceived in research can actually cause more harm than not. informing them. And so this is one of those, I think, considerations that the research community may not be aware of, and, to speak up if something doesn't make sense, because the
Right.
person reviewing the research may not know that either.
Terrific. Okay, so then if we have a problem, it sounds like we might have a problem again if we're sticking to the plain language of the regulations of characterizing this risk as minimal. That might be a problem. We probably have we probably meet the practicability in terms of the research not being, it's not practicable to carry out the research with the requested waiver. Excuse me, without the requested waiver. We are going to use identifiable private information, but that's actually manageable. It is identifiably, it's not identifiable information, excuse me, I should say we are going to use identifiable information, but it's not private. At least I don't think it is. You tell me, let me ask, are things that are accessible to anyone via the internet or upon a, say, Freedom of Information Act request, are those considered private? Because all of this criminal justice information in the United States, unlike in other countries, all of this stuff is available on the internet or via Freedom of Information Act or a simple inquiry to the court.
You're not going to like to hear this,
Mm-hmm.
but there's a good deal of inconsistency in what is defined as private.
Mm-hmm.
So, court records, by their nature, it's public information. You can go in and get it. Um, it's accessible with freedom of information, of course. More than likely, it's going to be redacted,
Mm-hmm.
that information.
But for
But
court records, you don't need that. You can just walk in and ask for them and pay for a
exactly,
copy. Yeah.
exactly.
Mm-hmm.
But if it is readily available,
Mm-hmm.
um, that would not I would not consider that private.
Right.
There have been some additional, people have added, the criterion of, do you have to get specific permission? And this really came about with like the advent of social media. Like, do
Right.
you have to be on Facebook in order to access that information? Then
Mm-hmm.
let's draw that line in the sand that that's considered private. So there are some IRBs that do operate in that way to give them some sort of structure and how they're defining things.
It strikes me as a little bit of a creative interpretation of private if it's available on Facebook to anyone who logs into Facebook. Now, again, it might be different because Facebook has different settings, social media has different settings, et cetera. But anyway, okay, got it. But again, court records, frequently in the United States, at least, all court records are presumptively public. There are certain categories that are exempt from that. Certain family law categories, for example. Then let's go to the waiver or alteration will not adversely affect the rights and welfare of subjects. And is that basically what we've talked about already? Is that sort of the idea that it might actually be a bad idea to get consent, or at least there's an argument that they have no, and this is something that comes up quite frequently in the criminal justice process. The participants here have no say over how the criminal justice system is conducted. They have absolutely no say in that,
Mhm,
except in the most limited settings, typically involving whether they take certain drugs. They still
mhm,
may have the right to refuse certain drugs, but they have no, for example, say whatsoever on whether a judge has a risk assessment instrument or doesn't. They frequently
mhm,
won't even know. They have no right to affect what information the judge considers and or whether the judge pays any attention. And they have, in fact, and this is an unusual thing in this setting, they have no right to even to speak to the judge to try to persuade them. Some jurisdictions do this without a live hearing. They make this decision. So there's no opportunity for the defendant to speak to the judge. There's no way to
wow.
do it. Right. So they don't even have the right to do that. And so this is a severely rights limited situation. With that in mind, how would you think about whether a waiver or alteration of informed consent in this process would affect the rights and welfare of the subjects?
Yeah. So I'm going to look at it from the perspective of what rights and welfare would a consent process provide the individual,
Mm-hmm.
right?
Mm-hmm.
So, again, I think this is more apropos to, I think, other research populations rather than within the judicial system,
Mhm.
given the limitations that are inherent
Mhm.
in it. So if you think about, a study that is involving deception, the person doesn't even know they're in a research study.
Right.
They're sharing their deepest, darkest secrets. They're sharing that, they've committed all these crimes, that they're this, you know, heroin user, they're in this very specialized profession, et cetera. And they're disclosing that not knowing that this is going to be part of a research study,
Mhm.
right? So that would definitely be a consideration.
Mhm.
And then the IRB would look is this research so important that, you know, perhaps we need to find out that information, but on the other side of it, we're going to disclose to them that it was research and they could decide whether to participate or not,
Mhm.
right? So a lot of IRBs will do that as well, given what that research is.
Mhm.
So, I would really look at this as what would the consent process afford to that individual insofar as their rights and welfare in the decision to take part?
Mhm. And here it would afford them virtually nothing because they have no control over any of the way in which the proceeding is conducted.
Hmm.
And so, okay, so understood. So then we have the last criterion, which is where appropriate, we're going to inform the subjects and legally authorized representatives. I can just tell you, this is in fact what the Harvard IRB, which you were running at the time, mercifully, did require us to do that I thought was actually quite shrewd. And what they did, what y'all did, was you required us after the proceeding was over, or in some instances before the proceeding, but well before the proceeding, to ask the local jurisdiction to hand out a single paragraph description of the study, along with a location that folks could go to in order to ask questions about the research, just informing them of the nature of it, and say, if you want to ask questions, here's where you go, basically giving them the access to Justice Lab's email. And potentially even inquiring about quote unquote opting out, which in this case
Hmm.
would not mean removing themselves from the criminal justice system, or all of them would have done it, not removing themselves from the randomization process even, but simply removing their data from the study. They could request. No one did, by the way, and we must have randomized over 6 jurisdictions. We probably randomized
Wow.
over 20,000 cases and
Wow.
never got a single email or a single request, a follow-up request. So we had no problem doing that. I thought it was quite a shrewd, quite a creative and good thing.
Hmm.
The IRB, great. We had not suggested that. That was y'all
Hmm.
suggesting that. But the IRB, in this case, did say that if I recall correctly, and I'm not 100% sure, but if I recall correctly, did say that the arrestees were participants. Therefore, which I thought was a mistake, did say that therefore default was to get a consent, and then did say that this study involved no more than minimal risk, which I thought was a second mistake. But it allowed us to go forward, and I wasn't going to complain because I thought they got the right result for the wrong reason, which is that they actually weren't participants, and therefore that we didn't need to go through this analysis. But and under the stipulation that we provide the single paragraph. So we again, we got the right result, but I don't think that I think the reasons were A, wrong, but also B, carry dangers with them. In characterizing something like extended incarceration as the possibility of extended incarceration as minimal risk,
Well, mind you,
right?
there was some, works cited included as well
Yes,
that provided justification that led to the minimal risk
right.
determination.
That's right.
So,
That's right. No, no, it wasn't a complete. I'm not saying it was irrational. I'm just saying I probably would have gone a different way. Let me
yeah.
just quickly. Oh, sorry. Go ahead. Sorry. Go ahead.
No, I was going to say, it's all about balance,
Hmm.
right? And
Hmm.
it's, the balance is ensuring that individuals that decide to take part in research, that they are making an informed decision about that.
Hmm.
And if not, they're provided with information to do so, but also creating a path that important research can move forward.
Hmm.
Because, think about, as you know, the societal benefits of this type of research, and how can you strike a balance such that individuals can have their rights and welfare thought about, but yet have this be carried forward. So I that's one thing is it's about balance.
Super.
Okay.
Okay, so then final set of questions, final one question, maybe two questions, deal with an entirely different portion of the CFR, okay, of the Code of Federal Regulations. And this is not the waiver of informed consent process, which is a part of the common rule that applies to almost all types of regulations other than drug and medical device, all types of research, excuse me, other than drugs and medical devices, and therefore governs legal research in the legal setting.
Okay.
But now I want to look at the regulations that do govern randomized trials, for example, standard clinical trials involving new drug approvals or new medical
Yep.
device, right?
Yep.
And the exception from informed consent, the EFIC as it's known, the
Hmm.
exception from informed consent occurs at Title 21 CFR, Section 50.24. And it actually starts out right around there at A, right? It just starts right out at A. And it says that under certain circumstances, an IRB can grant a waiver of a drug or a medical device research randomization, for example, under certain circumstances.
Hmm.
The classic case that at least I have found in research we're doing on this is an incapacitated patient in an emergent situation.
Hmm.
So, you know, the emergency medical technicians, the EMTs arrive in an ambulance. Somebody is bleeding out, and for example, and you don't know how to treat them for some reason. You know, there's something there. There's equipoise as to whether a famous example was whether you could use a blood substitute when you didn't
Yep.
have, you know, the right amount of blood or the right type of blood. That research had its own issues. But that was a famous example. Another one that's come up is therapeutic, basically freezing of people. Basically, you drop their body temperature extremely rapidly in order to prevent them from dying on the spot. Hopefully, they'll survive long enough to where you can get them back to the hospital and treat them. It's not clear. There's some suggestion that may actually help. It may kill people from shock,
Hmm.
right? We just don't know. And there's no time to they're out. They can't give you consent. You don't have enough time to contact a legally authorized representative or a surrogate decision maker of any kind.
Yep.
And I guess one question, and there's a whole set when you're in that situation, there's a whole set of requirements about when you can waive informed consent. And we won't go through all of them because it's proof over precedent is most about social science and law. My big picture question here, though, is that basically for the exception of informed consent doctrine or the regulation to apply, it typically has to be, number one, under the terms of the regulation, life-threatening.
Hmm.
So serious bodily injury, blindness, paralysis would not qualify because it's not life-threatening. Number two, it has to be an emergency situation. The regulations speak in terms of a
Yep.
therapeutic window it is very short.
Yep.
I would characterize that situation, both the setting and research in this situation, as extremely high risk.
Hmm.
Would you agree with me on that?
I would. And so at an IRB I was at many years ago, they did quite a bit of this research.
Mm-hmm.
And I'll give you an example.
Mm-hmm.
They were wanting to know if a new CPR technique
Mm-hmm.
worked.
Mm-hmm.
How else are you going to know that it works or not
Mm-hmm.
unless someone's in a life-threatening emergency situation? So this type of research, I mean, it's risky,
Mm-hmm.
right? I mean, here are people that are going to be a research subject. They're passed out. No one's there. Um, how are you going to have this happen? So this type of research, the ethic, is very regulated, as you know.
Epic
And
exception from informed consent. Yes, go on.
yep.
Uh-huh. Mm-hmm.
And so that one research study was testing out two different CPR methods.
Mm-hmm.
There has to be a community consultation.
Yep.
Okay. Now, it's a little squishy about what is sufficient community consultation, but, ads on the radio, television, flyers, different, community outreach, maybe an advisory group, et cetera, et cetera. And where the community advisory of that particular research study did all of those. And for individuals who wanted to opt out, they would wear a bracelet.
They wear a bracelet, or you could carry a card sometimes, right?
Correct.
So this would what come up with, for example, certain religions prohibit blood transfusions, and right, and so you wouldn't want to do a blood transfusion study with somebody that's carrying a card or something like that.
Exactly. So again, we're looking at balance. How can you have this research move forward while still protecting the rights and welfare of those who might take part? And so that was one aspect. And it was, that's very challenging research, and a lot of institutions won't do it a priori.
And so I just want to conclude then with one observation that I think to me demonstrates that we may need some more thinking through these things, especially for people who do not take the broader view that you did in this discussion, which is, let's go to the values underlying these regulations. Let's think about balance of research, need for knowledge, for, et cetera. It seems like the EFIC regulations that we just this second went over that apply to drugs and medical devices insist that the situation be extremely high risk before they were allow for before a waiver to go forward, before an exception to go forward, an exception to go forward. But that the common rule, which does govern the medical setting, insists that the regulation be no more than minimal risk before a waiver can be granted.
Yeah. Well, it is interesting though, Jim, in that regard, in that FDA, that was their only exception for informed consent.
That's right.
That was it.
That's it.
That's it for FDA regulated. However, they did sign on to that one waiver that's found in HHS about no greater than minimal risk. So that's one place where FDA and HHS are harmonized.
Right. Again, FDA part of HHS. Nevertheless, it does the drugs and medical devices regulations found at Title 21 of the CFR, whereas HHS general does the common rule.
Correct. And FDA is one of the few agencies that hasn't signed on to the revised common rule.
Right. Again, strikes me as very odd. On one hand, we insist on a high risk situation before we'll allow this. Another one, we insist that it be no more than minimal risk before we allow effectively the same thing. More things for me as a law professor to do, put it that way, to try to say, can you reconcile this? Should you reconcile this? Probably not. What should we do in that situation? Shannon, as always, thank you so much for spending your time and for your sharing your wisdom. And I will look forward to our next conversation if you're willing to have one.
As always.
Thank you so much. Proof Over Precedent is a production of the Access to Justice Lab at Harvard Law School. Views expressed in student podcasts are not necessarily those of the A2J Lab. Thanks for listening. If we piqued your interest, please subscribe wherever you get your podcasts. Even better, leave us a rating or share an episode with a friend or on social media.